Right, so this is your criminal appeals question, and this part is looking at how you can appeal from the Magistrates Court. Now, as you can see in front of you, you are able to draw this in the exam, right? So that's always a positive, the fact that you can draw it out as a diagram, as long as you correctly label it, okay? So all I'm going to do is take you through the bullet points. I suggest you revise it like this instead of how it is in the booklet, because there's just a lot of text there, that's all. So this way you might find it a little bit easier to go through. Right, so starting at the bottom then, down here, your trial has been heard at the Magistrates Court. Now, reasons why you might want to appeal then, generally, the defendant's either not happy with the sentence that they've been given, or they're not happy that they've been convicted. And they tend to be the main reasons why you would want to appeal. So starting from Magistrates then, you basically have two options as a defendant. You either go straight from the Magistrates to the Crown, or you go from the Magistrates to the Queen's Bench Division. Now, the reason that it's separated, this side is all in red and this side is all in blue. This is because blue is for the prosecution, red is for the defence, okay? Right, so Crown Court. As you can see here, only the defence can go to the Crown Court, which is quite good. So it's just the fact that we can go there as a defendant, the prosecution cannot. You then need to say that we have the automatic right to go to the Crown Court. So we we don't need to ask for permission to go. We have an automatic right. Okay, so you don't need leave to appeal. Why are you appealing then? You're appealing on either your conviction or your sentence. The appeal has to be made within 28 days, and when you do appeal, it'll be heard by a judge, and you'll sit along two magistrates. So instead of the bench of three, we'll have a bench of two, and a qualified judge making that decision. As you can see from the bottom, they have the ability to increase or decrease the sentence. So, for example, if the magistrates have given you 6 months in prison and you go on appeal, there is the possibility that the Crown Court will increase your sentence, or they could decrease. So you just need to take that risk while doing that. And then finally, they can confirm your charge, reverse it, or lower. So your actual conviction, they confirm that it is right and you still get convicted. They can reverse it and get rid of it, so you'll be what we call acquitted, let off, or they can lower the charge, so they could drop it from that charge to something else. So, for example, they could drop the charge from ABH down to a battery, okay, and that's the appeals from the Crown. If the defendant still isn't happy, he can go from the Crown Court up to the Queen's Bench Division, or, as said previously, you can go straight from the magistrates directly to the Queen's Bench. In terms of the defence then, the actual details over here at this side, she just needs to be aware that it actually belongs to the QBD. It does that bit, it's just we didn't have a lot of space. Now, if you go into the Queen's Bench Division, you can only argue on your conviction, you can only argue a point of law. So what we're doing here is saying that the law was misapplied or misunderstood by the magistrates. So you'd like to argue that you shouldn't be convicted. So if you want to go on sentence, you'd have to go to the Crown Court, because you can go on sentence, but here you can only go for conviction. So that is a deciding factor as to whether you go to QBD or whether you go to the Crown Court first. You do need permission to go to the Queen's Bench Division, and it'll be heard by two High Court judges. Again, they can confirm your charge was correct, reverse it, or they can alter it, they can lessen it, okay? The other thing that they can do is send it back down to the magistrate. So often what happens is they'll say that something's not right, but they'll send it back down for the magistrates to retrial and deal with again, because they have too many cases to deal with. So rather than them become backlogged, it'll be quicker for them to send it back down and your case to be heard there. Okay, final two appeal routes then. We can go up to the Supreme Court further, so from the QBD straight up to Supreme Court, and from there we can go to the European Court of Human Rights. Now the Supreme Court, because they only deal with on average 6 cases a year, your case must be very, very important for them to deal with. So as you can see, it says there that they only deal with matters that's a point of law of general public importance, so something that's really important to the public, a clarification on a point of law for murder, for example, for manslaughter. A lot of high-end drug cases have gone up there, something that's really, really important to the country, that the law gets sorted out, which is why there's only 6 a year. Okay, you do need permission, so again you need leave to appeal, either the QBD to go up or the Supreme Court to go down. When you need permission, it's either the court going to or the court coming from that you need to get that permission from. And then finally, if your case is involving human rights, so you're arguing your human rights have been breached, you can go to the European Court of Human Rights and get a decision there when you appeal. Just bear in mind though that the European Court of Human Rights is not binding on UK law, so we don't technically have to follow it. Okay, right, that's the defence side then. The prosecution, you can see, very, very similar, so I'm not going to go through the final two. These two here are exactly the same as the defence side, so the prosecution go to the Supreme Court if it's publicly important, as and with the European Court of Human Rights, the same thing. The other thing that's slightly different is when the prosecution are arguing their case at the Queen's Bench Division. So some of it is the same as this side but obviously the prosecution are not arguing on conviction. They're arguing that you've been let off when you shouldn't have been. So if you just want to make a note, acquitted just means let off. So if they're not happy that you've been let off, they will appeal it from the Magistrates Court straight to the Queen's Bench Division. Okay, same as you, they need leave to appeal, so magistrates say yes to go up or QBD says yes to come up, and again they will send it back to magistrates to get that final decision sorted, but everything else is exactly the same. It's still 2 out of 4 High Court judges. You are still arguing the point of law. The prosecution is arguing that the magistrates misapplied the law, and they have a full retrial, so that's why it's known as case stated. Now, if you had this diagram with both defence and prosecution, it would be worth 18 marks, so the full 18-mark question there, but you need to draw it and label correctly, as I have here. So make sure you include all the correct bullet points and the diagram is in the right order. If they wanted just the defence, you would just do the red side, but that would only get 9 marks, so they would normally be asking something else, maybe the defence from the Crown Court as well. So they can mix and match, so you just need to be careful there. But that's your criminal appeal diagram from the Magistrates Court.